2024 at 10:41 a.m.
This matter is before the court on the defendant's motion to enforce and modify child support. I've read all the pleadings in this matter. Ms. Parr, I don't quite understand. You said that this order was entered back in 2017, and I don't understand why it would take 4 to 5 years for you to correct any inaccuracies that you stated occurred, basically 5 years ago. And again, the allegations that you make as it relates to the referee do appear to be fantastic. So I'm at a loss as to what you're alleging.
Your Honor, I was very weak after treating like some kind of narcissistic abuse that for so long, and I was afraid to bring things up. And every time I have a trial, they told me not to, and now I was alone. And I think that's the only way that the court can see things clearly.
Okay, so what's the basis for your motion?
As the law said, when there's an exiting case, everything has to be filed on the exiting case. Instead of this case, they just come out with a new case without the court involvement and take over the old case. And when I was suffering financially to taking care of my kid.
Okay, well, this case was consolidated back on February 5th, 2018. And that's not unusual that if you got, a support case and a different, like in this case, the DC case, the cases were consolidated. That shouldn't impact the case at all because you can still make any corrections that need to be made. So again, I'm still not understanding what you're asking for.
I am asking for your honor because of all 2 years unpaid child support. That's what I wasn't able to come up with money to hire a attorney to presenting me until everything went downhill.
Okay, that still doesn't tell me what's the basis for your motion. You're saying you didn't have money to be able to fight it at that time. That's understandable, but it doesn't tell me why we're here today and what the basis is for enforcement or modification.
Well, they consolidated without the court involvement of February 5, 2018, but does not include the support order. I take the attachment. They cross out with a pen. And because of that, I never received any support, nor I can even dig my stuff. So life is just like a nightmare with 2 young kids, and to still affect the case today.
So are you saying that there is no support order at the current time?
No, Your Honor. That order has been finalized on December 2017, but I does not receive a penny since the day you entered the final order, Your Honor.
Okay. Well, maybe I can get Mr. Spring. Maybe you can enlighten me. What's happening if you know?
He probably know because I am not aware of.
Okay, I've turned it over to him. I want to hear from him. So, Mr. Spring, enlighten me what's happening.
Okay. We've gone through several evidentiary hearings with the front of the court, and this is a support order that was put in place by front of the court, not by any agreements or anything like that. So this is just the state putting this order in place. The children live with me full time. Ms. Parr only sees the children for an hour a week supervised. So she pays me child support, and that's it. There's nothing other than that.
Okay. Ms. Parr, is that your understanding that the support order basically obligates you to pay support? You are the support payer?
In the DC case, yes, Your Honor, but in the DS case, you awarded me full custody of both the minor children until the DC case come out in 2018. And then Mr. Spring just start setting a trap with me, all witnessed by the minor children. I attached all the police report as well. He against me in PPR with false police report. And then that's how the DC case come out with the court, without the court involvement. And also in May 2023, 2018, they told me we have meditation at your courthouse. And I was there, witness with Marco from the said place. They told me if I did not sign a halfway cut down the child support amount on the DS case, on the DC case, I will never receive a penny. And that time I already took 10,000 personal loan just to buy everything needs for my kids, and
Okay,
this
ma'am,
keeps going on.
try to focus on the motion. You filed a motion for enforcement and modification of child support. I don't need to get into all that extraneous stuff. I just want to know what's the basis for your motion.
Everyone should obey the court order, Your Honor, and this is the order still alive because they did not conciliate with the DHC case. They only consolidated the custody case. You can see that they cross out with a pen.
Okay. Well, in this particular matter, the only thing I could suggest, Ms. Parr, is that you proceed through this matter with the front of the court and see if you can't straighten out, again, the consolidation and the other, because quite frankly, as I look at this matter, as Mr. Spring states, there's an order for requiring you to pay child support, so it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. There'd be no issue in that regard. And apparently the front of the court has not pursued any action in this matter as well to enforce the order. So I'm really, as I stated, I'm at a loss as to what the situation is in this particular matter. So all I can say is you might want to proceed with the front of the court, as they have obviously involvement in both cases, the DS and the DC case in this particular matter. So the court just doesn't find a basis for the motion at this particular time. So I'm going to deny that motion. Mr. Spring, I'll ask in this matter that you would prepare an order denying the motion. And you can submit, if you submit that within 7 days, you can do it without having a hearing. And if you don't, then you're going to have a hearing to get the order entered, okay?
Okay.
Okay. Thank you. The court will end this matter at 10:49 a.m. You're free to go. Have a good day.
Well, I guess I'm going to go ahead and call this case. Calling case 2023-3075 DC, Angela Davis versus Faith McCoy versus Michael Hall. Today is Monday, January 29th, 2024 at 10:52 a.m.
Court will note the appearance of Mr. Bartel on behalf of the plaintiff. This matter is before the court on the defendant, Ms. McCoy's motion for court-appointed attorney. In this matter, the court will note it is now 10:52 a.m. and the defendant, Michael Hall, has not appeared in this matter. Ms. McCoy, you can proceed.
Hello.
You can proceed. It's
With
your
what?
motion. It's your motion.
Oh, do you want me to read it?
No, I want you to argue your motion. It's your motion. You can state what you would like to state.
I don't really know exactly what to say.
Okay. Well, let me go to Mr. Bartel. Mr. Bartel, I have read your response in this matter. Is there anything else you'd like to add?
Your Honor, I think my response says it all. We just we disagree. I think the statutes she indicated actually are not applicable, so we would ask that you deny the motion.
Okay. So Mr. Bartel is asking that I deny the motion. What's your response, Ms. McCoy?
I say that you don't. Everything in that motion that stated is true. My
Okay.
son was taken from me at the time without stating that he was an Indian child. I was not missing for a year when my son was taken from me, like Michelle stated, and got guardianship of him. She came and took him right from my arms, right out of my hands, right in the house with a paper in my face. I didn't even know what was going on. I was very confused, being abused by Michael at the time with guns being put to my head and everything. And she took my son from me. I had no help. I had no rights. I didn't know what to do. So I had an Indian attorney wrote that up for me. I have an Indian tribe behind me on all of this. And they wrote that up, and I would be very mad if it was not. And I will be too.
Okay. Well, the court will note the court has had opportunity to review the motion. The court will note that specifically child custody proceedings are excluded under Indian Child Welfare Act, as well as the Michigan Indian Family Preservation Act, being 25 USC 1903 parens 1, MCL 712B.3 parens B parens V1, as well as Michigan Court Rule 3.002 parens 2, at least as it relates to the court-appointed attorneys. So the court, as those are excluded proceedings, there is no basis for the court to grant an attorney in this matter. Ma'am, you have every right to come in and argue anything you'd like to, but the court will not appoint an attorney in this matter to represent you. So, Mr. Bartel, I'll ask that you would prepare an order denying the motion.
I'll do that. Thank you, Your Honor.
Okay, thank you. Court will end this matter at 10:55 a.m. You're free to go. Have a good day.
Thank
All
you.
right, thanks. You too.